I wonder whether you can hear me and whether the readability is good enough. Thank you. Well, in Russia, the interest towards patent law is not that high as it is in other countries of the world, and due to the organizers of the forum, we use it in order to popularize patent law. And we would like to discuss most vital issues and trends in the development of the patent law. And we are very glad that our speakers responded to our invitation. And before we begin our session, I would like to introduce our guests. We have here among us outstanding specialists, and I'm quite happy that we managed to get them together in this rather small room. And first and foremost, I would like to introduce Vladislav Ugrumov. He has a huge experience in various legal companies, and Vladislav is a well-known specialist in the patent law in Russia. Well, in Russia, I have to admit it, we do not too many companies that specialize in the patent law. And there are a few companies which specialize in the details of the patent law. And then I would like to introduce Thomas Voigt. He is a judge of the Federal Court of Germany. We know what prestige is enjoyed by the court in Germany. And it is well known not only in Europe but throughout the world. And Thomas is a professional, and he's dedicated his lifetime to patent law and protection of the patent law. On the right is my colleague from the United States. He is the head of the American Patent Office. Teresa worked for many years, worked as a practicing lawyer. She worked as a lawyer, and from this year she is a deputy head of the American Patent Law Office. On the left are the leaders of the European Patent Office, Raymond Pud. Raymond has a very long court career, and he in the past was the head of the court in Germany, and I had the opportunity of meeting him several times at different fora. Yuri Kuznetsov, representative of the company Gorodetzky and Partners, it's one of the specialized patent companies and patent offices in Russia. It has a very long history. It started its activity in the Soviet Union, and this company is already 52 years old, and it is well known in the country. Then Quentin Rombe is from Africa, and he spent there quite a lot of time. Cambridge IP is the company that deals with the patent analysis using contemporary methods and techniques, and the investigations that the company are carrying out. Well, they do it in close cooperation with the WIPO, and they are leaders, in fact, in the study of patent information. Manny Schechter represents the IBM company. IBM company is a key partner of Skolkovo, and this company is the leader among patent holders. And quite a big number of patents issued by the company, and they earn a lot of money on patents. And we cooperate with the IBM company. We also want to borrow their experience, and we hope that our entrepreneurs would get themselves familiar with the practice of the IBM. So this is a team that I wanted to represent, to introduce, and I would like to start our discussion. And the first question, I would like to say at the very beginning that I wanted to organize a rather provocative discussion, since, in fact, international regulation in the patent law appeared quite a long time ago, more than 100 years ago, and since that time, economic relations changed quite radically. Technical progress is rapidly developing, and developing at a higher pace than it was developing before. And therefore, the question is whether the modern patent law tallies fully with the tasks and objectives, with the aspirations of the people, and whether it stimulates the creation of new products, since the project law is a monopoly. The monopoly, as is interpreted by many people, is a kind of an evil which prevents the adequate development of the economy. And the limited monopoly on the country may stimulate innovation, to stimulate creativity and create new products. And therefore, the issue of today is whether this monopoly continues to be really effective as it was before, and whether it tallies fully with the objectives put forward before it. And that's briefly will be the subject of today's discussion. And our colleagues represent both private sector and national sector, and taking into account your public statements on this item, I would like to call upon you to be more active, and I would like to start with the representative of the private sector, and I would like Vladislav to take the floor so that he would give his opinion whether patent law should proceed and how it should develop. Or, well, from the point of view of a private sector, I presume that in industry, patent law remains, as it was before, a locomotive of technical progress. And the essence of the patent law, as has already been mentioned, is that the author discloses his innovation by this way handing in a patent application. And in response to this disclosure, the state or the community in the face of the state grants these author exclusive rights to these innovations, so that he could return all the resources that he spent for the development of his innovation. Well, the existence of the exclusive right has the life of only 20 years. And I would like to say that this is the shortest period of time. If, for instance, the life of the copyright is 50 years since the death of the author, then the life of the trademark will not be limited at all. If, for instance, it was registered, but with a patent, it is 20 years, and there is no possibility of prolonging this life period. And at the same time, the possibilities of the patent law, well, for instance, several sectors of the industry, they all use patent law. Let's take, for instance, pharmaceutical industry. Not a single medicine could be developed without the availability of a patent. And this is the main essence of the pharmaceutical activity. Well, this is quite a huge lump of money, and the pharmaceutical industry may receive all this money only by receiving, by getting the patent and protecting the patent. Well, they have got the life of not 10 or 20 years, but about 15 years to return all the money that was spent for the development of a new medicine. Well, the life period of the patent protection, from this point of view, is rather short, but there are certain companies that begin to manufacture generics, and but at the same time they save a lot of money because they do not have to invest money into the development of a certain medicine, and therefore any state is interested in the development of innovation activities on the territory of the country. And therefore, in this particular case, patent law is absolutely necessary for the development of the conditions so that the big companies would take decisions of principle in the innovation activity. With this purpose in view, apart from the intellectual property as such, we have to create adequate corporate legislation so that a company would have taxation benefits, and the state should stimulate the development of innovation companies by joint funding these projects. And therefore, with this purpose in view, we set up this Skolkovo Foundation, and we do our best to maintain the activity of this foundation, because this is the only chance for the Russian Federation to become an innovation country, since the scientific potential that was in the Soviet Union for the last 20 years was somewhat lost. And apart from creating favorable conditions for innovation activities, for investments into innovations, of paramount importance is the development of the patent legislation from the point of view of receiving a patent. For instance, whereas the patent that is protected by the patent law, the owner of the innovation should be absolutely confident that he would hand in his application to the patent office, and the patent office will grant him a valuable patent. And with this purpose in view, we have the structure of the Rospatent, or for instance, the Federal Institute of Industrial Property, and we are happy that with us we also have director of the Federal Institute of Industrial Property with us, and this type of innovation activity is extremely important, because Rospatent is the one that inherited all the activities of Gospatent. But nevertheless, they still have a problem. For instance, the legislation is changing, and FIPS and Rospatent sometimes lag behind these innovations. Besides that, it is quite evident that we have to provide the quality of examination. And from this point of view, it is quite a difficult problem, particularly with the personnel, because the significance of an exam is very important, but at the same time, it is not. This profession is not very prestigious, and the real life of a patent usually begins after granting the patent, and the rest is just a preparation for the life of the patent. And the rest is just a preparation for the life of the patent. And the life of patent begins after it is granted. And here we face a rather gray zone, since the life of a patent is the main objective is the protection of the patent rights. And since this trend in the activity is quite new, so we have to accumulate the critical mass of information. Besides that, we also should have economic prerequisites. Sometimes we have very heated discussions, and therefore of late, we witnessed quite a big number of patent disputes. And we have with us a representative of the arbitration court. And this arbitration court is the locomotive in protecting the rights of the patent holders. No doubt, mistakes are being made, but we have to use this method of trial and errors. But we have already accumulated rather rich experience in this area, and once again I would like to underline the fact that the patent law is a technical aspect of the activity, and recently in the Russian legislation system we think that the mistakes made by judges can be explained by the court disputes, and we have to replace the applicable practice, and we hope very much that the patent court would, or better say, a patent on intellectual rights would protect fully and adequately the rights of the intellectual property. Thank you, Vladislav, and I would like to address our second Russian participant, and after that we shall start statements that will be made by our foreign guests. Well, I would like to initiate the discussion and disputes. No doubt pharmaceutical companies invest quite a lot of money into the development of new medicines, but at present medical studies could be conducted much faster than it was, say, 100 years ago. And the second thesis of my statement is that the company, during a certain period of time, may also improve the medicine that has already been patented, and then the life of this patent will start anew, despite the expiry of the life period of the previous patent. And let's assume that this life period will be reduced. The protection period, then it will make the pharmaceutical company operate more effectively in order to create new medicine, realizing that this monopoly, the life of this monopoly will be a little bit shorter. And besides that, there's some other things to be taken in mind. For instance, a trademark which allows the company, and after the protection of a trademark was interrupted, then once again they have to take this into account. But from my viewpoint, it is not that dreadful. It is not, no doubt there are certain spheres of activity where these expenditures are less, and without going into details regarding the protection of software, nevertheless, the IT technologies, they are modified much faster, because nobody thought of this technology some 100 years ago, or even the last 10 or 20 years. During 10 or 20 years, this technology will become outdated, and to say nothing of the life of the patent. And I would like to give the floor to Yuli, so that our guests will be more active in taking the floor. Thank you very much. I do not represent pharmaceutical industries, but I can voice my own opinion. Now, this problem, to this rather extent, the sufficient of the life period of the patent for receiving just compensation of the expenditures spent for the development of innovations. But these pharmaceutical companies lobby this problem to a great extent compared to other companies. But what we see on the surface, all this is quite good, but the path of microelectronics is also uses the trial method. I think that the only thing that could be explainable why pharmacologists require specific conditions of their activity is mainly it's the stage before a medicine appears in the market. The stage which needs time for the testing and certification and of medicine or herbicide or something else. But it seems that the company in this particular way pharmaceutically find themselves in uneven conditions and unequal conditions compared to other companies. But for instance, let us recall Aberration in order to introduce into life a new, say, flying device. Then in that particular case, this is actually the remark with regards to the life of a patent. Yes, this is the dark side of the patent system. I mean, the life period, which is given and which quite naturally would be desirably will be should be increased by the patent holders. And the person who received this patent, I wonder to what extent it will be good in his further life. In the absence of competition, everything finds itself in stagnation.
Well, it happens often due to large scale of patents, but whether it will go to be a good situation for such a patent holder when he for many years would be alone in the market, would be going through a trial and error path, and he would not have a chance to see others when his patent period is over. Those who concealed would go to the front. Such situations occurred in the market, and there were companies which in such situations would lose their competitive advantage. Fortunately, as of now, with a large scale patent practice, it is really difficult to get such a wide protection patent so that to block any headway for others to work in the same area. In this sense, I believe patent system ensures itself. But coming back to the first question, which Igor posed, and I liked it, what are the developments of the patent system? Now I would like to share with you my comments. Well, the most difficult thing in the patent system, and from my point of view, is it's a very specific system in which you simply have to be an expert to understand what you're supposed to do. On the other hand, the patent system calls upon other people to protect their interests. It must be liberal and must be conservative, because if it starts to issue patents for all and everything, that will not be a totally different story. Further on, the very nature of the expert review, the depth of the expert review which an patent agency is supposed to implement, depends a lot on the resources of the agency. And here I would like to highlight such phenomenon as regionalization. In this sense, I would like to refer to the European Patent Agency, where a number of countries agree to have a common body which would be indulged in patent expert review and then issue patents applicable in many countries. And the third issue which should facing, the third challenge, it's a reverse side of the patent system, protection. Given a chance to play the monopoly role in exchange of disclosure of certain information. And the numbers for, replicating inventions are colossal. About 5 years ago, European Patent Agency said that 60% of the research are replicated because people fail to consult informative resources and do the same work again and again. And here, the patent agencies and specialized firms in making available this information in the best possible form to their consumers who would like to be involved in innovative activities. But right age patents is not the best choice. Here, we simply have to have a component of study, of research, which has already been done by others. And this is the culture of using the patent system. Those are some of the comments which I would like to share with you. Thank you very much. And I would like to pose another question address I would like to ask another question. You know that in the United States, the U.S. Patent Agency issued many patents, many patents indeed, and it is no small wonder that it is the United States that we are witnessing patent wars. This is connected with the fact that quite often, no matter what you may invent, everything has already been invented. Even you may not even know that what you're working on has already been patented. So such patent wars do occur from time to time. And I would like to learn your attitude to such phenomena, whether it is good or bad. What is the policy of the American U.S. Patent Agency, whether it supports or stimulates the greatest number of patents to be issued, or whether it realizes that it's not good. And the second question which I would like to have your opinion upon, what do you think about the improvement of the expert review before a patent is issued? Whether will it require some improvements? Should it be improved, or the current level of the expert review which you have in the States in your office is sufficient?
Thank you so much, Igor. I'm not certain I completely got a complete translation of everything that you said. So if I do not specifically address your question, please kindly interrupt and clarify. I think your first question went to, is the U.S. patent system efficient? Is it doing its job? Does it promote innovation? And does it operate as it is intended? Is that accurate?
Yes, and I would like to precise that my question was that
yes,
office issues a lot of patents, and sometimes it causes patent wars, and and we understand why it is so, because when there are so many patents, there is a great possibility that someone violates the patent of the other person, and so it's. The second question was about the examination process. Do you think it's a good one, or should be improved somehow? I think nothing should be changed.
Okay. Neither one of your questions is easy, so I will take them in the order requested. With respect to patent wars, that is actually not a unique phenomenon. One of our colleagues at George Mason University, a law school in Washington, D.C., actually in Virginia, just drafted a paper and went through all of the patent wars in the sewing machine technology. So patent wars, while to you and I, the numbers and the damages and how people are fighting seems unique, but in reality, those trends have been consistent through the over 200 years that the United States patent system has existed. I think that for common members of the public, they do not completely understand patents and what they are to do, and the numbers and the value of those patents and paying billions of dollars for the patents don't necessarily make sense. However, I do think that the patent system promotes innovation, and it is doing as it was intended to do, because you have noticed nobody stops making computers, nobody is stopping making software, nobody says we have enough cell phones, let us stop now. We want to know what is the new toy and the new gadget that we will have for the future. And so we still have companies who are innovating. Now, those companies would not innovate if they did not think that they would have some exclusivity and some opportunity, as my colleague indicated, to get back the value of their investment. Nobody wants to do all of the work and spend all of the money and be immediately copied. And what I like to tell people, in the United States, our patent laws are over 200 years old. And part of the reason that we have patents and copyrights specifically in the United States Constitution is because George Washington and Thomas Jefferson were very intelligent. And our country was not very sophisticated. Europe was much more advanced, much more sophisticated, and they did not want to always bring in technology from Europe and to pay royalties to Europe. So they wanted to promote innovation into our very unsophisticated country and to promote innovation and to give the American public confidence that they could not be immediately copied. Now, the sewing machine wars were somewhat similar to the wars that we are experiencing right now in high technology. And it also was cross-border. It was not just the United States. It was between Europe and the United States which sewing machine patents would succeed. And if you have an opportunity, I suggest that you read that law review article, because what we think we are experiencing today is unique. It is actually not unique. However, the American public does not want to pay very much for their toys, and they think that they are paying so much because of the cost of the patents. And it is not necessarily expensive just because you have a patent. I have to tell you, patents also in the area of pharmaceuticals, if I can digress a moment, most patents are what we call incremental innovation. People disclose to the public, you see what I invented, and then you say, I will work on that and make it better so that you too can have a patent. That is what we want. Most patents are incremental innovation. And for instance, the light bulb that Thomas Jefferson has given the credit for having invented, 3 inventors invented the light bulb within a 2-week time period. And it was in an interference proceeding in the U.S. Patent Office. They decided that it was invented first by Thomas Edison and his team. So it was this tremendous invention, a light bulb, the filament in the light bulb so the light would shine for a long period of time. Tremendous innovation, but it was a tiny innovation over what was known. What we actually like to try to do is disruptive innovation. Innovation that will change how things are done. The computer completely changed every business and how everything is done. In the area of pharmaceuticals, we now have biologic products that actually are changing medicine, and more biologics are approved than traditional oral tablets or small molecules. So what patents do is give business confidence to spend the time to do the research to try and bring to us either a new life-saving medication or a new toy. And I especially liked that you said it is for a limited time, only 20 years, but then you said, but you can extend it by continuing that work. Now, for instance, in the area of pharmaceuticals, if I invent a good drug, but there are some undesirable side effects, and you make a small modification to that drug, and the side effect is not there, I think your work was valuable. I think you deserve a patent. And as the patient, I want his drug, not my drug. What you also do in pharmaceuticals is many tablets that we take by mouth must be administered 4 times a day. That is much too often. Americans cannot remember to take their medicine on time, so we need it simple. We would like to take our medicine once a day, and the new technology takes old drugs and try to have it administered once a week, and in some cases once a month, and some medications to keeping calcium in bones can now be administered once per year. And that is just tiny innovation, and you say, but the drug molecule was known. Why should you get more exclusivity, more time? because I want to take my drug once a year. I cannot remember to take it 4 times each day. But there are different philosophies, and when I look at the patent system, I want to help business get the confidence to invest and to make my life easier. So I don't care about issuing useless patents. I want patents that will change my life. Is that okay with the first question? Now, the second question is within the U.S. Patent and Trademark Office, our examining procedures, and to try and, we are in the constant process of modifying and changing what we do so that we issue what we consider to be quality U.S. patents. The U.S. Congress tells us how to do our job. The courts, judges, they tell us how to do our job. So we have many people who try and help with us, and we have to balance many interests and many things that we are told. Sometimes the instruction we get from the courts or Congress is not perfectly clear, and we get questions of first impression, and we do struggle with those within the U.S. Patent and Trademark Office, and we make our best decision with what we issue. In terms of quality of issuing good patents that will not be later found to be invalid, what I think will be the most effective there is something that we call work sharing. And Mr. Lutz from the European Patent Office is here, and what we are trying to do is, instead of each of our examiners duplicating our efforts, as you indicated, nobody wants to duplicate the discovery. No one wants to reinvent that which is already known. But likewise, in the U.S. Patent Office, we want to work with the European Patent Office and other patent offices and not duplicate the search and the examination that each one of our talented examiners do, so that if the European Patent Office examines an application, identifies allowable subject matter or allowable claims, and they come to the United States, we are trying to work with our examiners to say, respect the quality of that work, do not duplicate effort, but rather add value. Is there a different search, tiny search that can be done? Or is there something different that we could add value so that we get a higher quality patent out of the U.S. Patent and Trademark Office? We also have a lot of metrics within the U.S. PTO where we try to issue quality patents and we try to make sure we are consistent. We issue over 350,000 patents each year, and so it is difficult to be perfect with quality, but we actually are constantly striving to change. Just like technology changes, we are trying to innovate our new procedures within the USPTO so that we could provide businesses with a better quality patent so that we will give business the confidence to invest in new industries and new products so they create jobs so the economy improves. And that is why we are in business.
Thank you very much indeed. I have another question to go to Manny Schechter, and Yuri referred to the fact that the modern technology allows us to analyze patent information. The access to patent information has become much easier these days. What are the advantages that IBM and you personally see in, making such access easier? And I would appreciate it too if generally you would tell us more your vision about the prospects of development of the patent legislation, if you think that something has to be changed in this area.
Okay, thank you very much, Igor. First, to your question about access to information. Actually, in the United States, I have read quite regularly in recent years a criticism of the U.S. patent system that it fails to provide access to information, not because the information is not in the patents, but because many companies and scientists indicate that they don't read patents to get that information, and that therefore the system objective of bringing that information forward has not been met. I would disagree with that. To whatever extent it might be true that scientists and engineers don't use patents for that purpose, the fact of the matter is that in most companies there is a procedure before which any information can be released from a company, which includes the filing of a patent application. So in IBM, if one of our scientists wants to publish a technical paper, he or she will come to my organization and we will review that paper and consider filing a patent application on it. And if we decide to file a patent application on it, we won't allow the paper to go out until we have filed the patent application. So while others may not be reading our patents to gain access to the information in them, the other channels that they are using, the technical publications, would not exist but for our patents and patent applications. They are clearly linked. And for anyone to suggest that the system doesn't serve that purpose, I find to be an oversimplistic view of the system. So in IBM, we absolutely think the system is helping in that regard. And we think of patents as the culture of innovation, and we like to think of ourselves in the United States as the most innovative company because we get the most patents. Now, I've forgotten the other part of your question. If may I comment on one or two things I have heard? My colleague from the United States responded to your question about the patent litigation war that seems to be going on in part of the technology industry in the United States. And she mentioned that it is actually not new. Not only do I agree with that, but I would characterize it a bit further. I would say that those litigation wars tend to occur early in the life cycle of many technologies. And what typically happens is if a war breaks out, we see a series of settlements or occasionally case holdings, case outcomes, after which the litigation quiets down and the industry resumes its practice. And if you look at the technology industry, in particular the smartphone industry, it appears, I am in no position to know for sure, but one could easily argue that the reason for that war is because there are a large number of companies in that industry that have lots of cash, but no patents. In other words, they have entered an industry without getting patents, and they are now being forced to perhaps pay their dues, so to speak. And so I might say that if they had invested in their patents early on, there might be no war. In other words, the very patents that people are sometimes saying are causing that war may actually have prevented that war had more existed. So it is not as simple to say that simply because there is a burst of litigation in the smartphone business that something is wrong. In fact, in many ways, I think something very normal is happening, and it will quiet down, and things will resume as they always do. As for whether the patent system is working well, for a while in the United States, there were it was very fashionable for critics of the U.S. Patent and Trademark Office to say that the patent system is broken. We have never believed that in IBM. Our personal position is perhaps different than others. We find ourselves in a less extreme position than many other participants in the patent system in the United States and indeed the world. Many of the most vocal critics of the patent system tend to be on one side or the other. That is, they tend to be very pro-patent or very hostile to patents. In IBM, in the United States, we have the most patents. We generate a lot of income from licensing our patents. But we are also much more regularly sued by others than we ever bring litigation against third parties or against our eventual licensees. As a result, we actually have a viewpoint that often surprises people. People think because we have a great deal of income and a large number of patents that we would always want a stronger and stronger patent system. In fact, we want a system with the appropriate balance, a system that allows us to enforce legitimate patents for legitimate inventions, and one which also helps prevent the meritless patents from ever being granted in the first place. And it is that about my organization which frequently surprises people, and it is for that reason which I believe my company is uniquely qualified to comment on whether the patent system is broken, and we indeed think it is not. Perhaps it is slightly out of balance in points, but broken it is not.
Спасибо большое, Мэнни.
Thank you very much. Well, indirectly, we have started to discuss the monopoly issue. Quite often you are accused that as a holder of the largest number of patents in the USA, you seem to make the patent system more rigid, more stronger. In this respect, I would like to ask a question to Thomas Voigt. It would be interesting to learn to what extent courts dissolve conflict between the situation when the patent is a monopoly on one hand, and on the other hand, the application of anti-monopoly laws to regulate the market where patents are also in play. In my mind, in Western countries, along with markets of goods, we see now a market of results of intellectual activities, market of patents, when patents quite often are bought not only to produce a good or goods, but only to prevent others from producing goods and enter the market, or then to resell the patent. So some kind of a derivative patent market has come to be. Well, if we compare some financial derivatives, of course, you understand, I think. And we believe that sometimes we see a challenge that it is necessary to apply anti-monopoly law in such cases when holders of patents abuse their rights. Have you seen such situations? Is this indeed a problem? What your comments could be? How can we address this issue?
Thank you, Mr. Dorostov. Let me start. As my colleague said, I don't think there is a real monopoly because you have to disclose, there's a disclosure of your invention, and you have to look at the time between an invention and an innovation, which lasts in some fields of technology more than 10, 15 years to get on the market. And so the danger of a monopoly is not so real because there is a possibility or opportunity if there is a real monopoly, like in pharmaceuticals, then you can provide in the law system, like Germany has, a compulsory license, which has to be granted by the court, but only if someone is applying for it. And it's quite rare because I never experienced a compulsory license proceeding. Just one application which was withdrawn a short time later when the parties had made a settlement. So I think there is no real danger of a monopoly because the time limit of a patent is too short to build a real monopoly. Maybe if you look at the copyright, there is the time, the duration of protection a lot longer, and there is more danger to exclude others than in the patent system with the 20 years of protection. So actually, if you in my opinion, if you look on the other hand to the fact that the patent system only prevents the imitation but supports the inventive doing of a company, I think there is no real danger of a monopoly, and no one is prevented from inventing new things beside the protected subject matter.
I would like to address my next question to Raymond, so that Raymond would share his version of how we should modify patent law and whether any changes are necessary to introduce into, say, the system in Europe, and whether the system is an optimal one. And I would like to listen to your vision in the process of examination. Very often the Russian entrepreneurs complain, and this question was put forward at the session of the European Union, that this examination takes quite a long period of time. And when patent is granted, the technology is already obsolete. So what can you say, whether there are any methods of using rights to intellectual activity before the patent is granted? It is just when it is just on the stage of an application, and whether it will be possible to realize
it. Igor, for this question, and thank you also for the invitation to this panel and to the forum for a person, for a lawyer like me, who is not only interested in patent law. It is a unique opportunity to attend also other fora and to get well known as how the evolution of law is. Well, to the patent system. I think the patent system we have today is a balanced system. It was already mentioned and explained that the interests of the patent holder and the interests of third parties of the society are more or less balanced. When you are just mentioned the question you asked beforehand, you mentioned these patent wars. Well, you can read it everywhere in the newspapers because it is interesting for the public to read about. But when you look at the figures, we have, for example, in Germany, which is my home country, we have about 800,000 patents in force. And we have patent litigations in Germany about 500 to 600 a year. A very low rate. And we have so-called nullity cases when the the validity of a patent is challenged on a number of 200, 250 per year. This is really a very low number, I think. And this gives, in my opinion, an indication that in principle the system works well, and there are some cases, where there was the examination not good enough. These can be then re-examined by a court and re-decided. So I think for the next 20, 30 years, there will be no big change in principle in the patent system. What we are doing today is to make the patent system more efficient, not to re-examine, as it was already mentioned by Teresa, to do the same work in each and every patent office in the world, all over the world. The biggest success in this respect was the creation of the European Patent Office, because, we have now 38 member states, and if you would like to have a patent in these 38 member states, you need just one patent application, one patent examination procedure, and then one patent granting procedure. In the past, before the existence of the European Patent Office, you had to apply in all the 38 member states for your protection, and had hundreds of, not hundreds, but 30s or more patent attorneys working on these before all these patent offices. This was a big step forward 40 years ago. Our founding fathers were very wise in this respect. And what we are doing now is to do more or less the same on the world level. We will not create, during my life, I think, lifetime, a world patent office, but we will come closer. The big patent offices of the world will come closer with their procedures, with their rules, and then also it would be easier to utilize the work one patent office, for example in the United States or in China or in Russia, has done, to use this work also in a procedure we have just before the European Patent Office, and vice versa. And this will be the main challenge, I think, for the next 10, 15 years, to harmonize the procedures, not to change the patent system at all in the fundamental. We have, you know it, I'm sure, we have this TRIPS agreement where the cornerstones for the protection of intellectual property are written down, and these cornerstones will not be changed in the coming 20 years or so. What is my vision, or what should we think also of, is, it was also already mentioned, that the patent system is not only, and the patent offices are not only machineries to grant patent protection. The patent system has two pillars. First one is to grant patent protection. Second one is, to inform about the content of the patents, to disseminate patent information among the public, and this is at least so important as the protection for the inventor, to get the public, to get third parties, the possibility to access to this innovation in order to build up on this innovation and to create perhaps new things. This is the justification of the protection for the inventor. And I think this patent information is becoming more and more important also. and the use of this patent information is even more important in the future than it is today. But here, well, there are sometimes limitations to access to this patent information. Just to mention, the Chinese government decided to have within a 5 years period of time about 1 million patent applications per year. This is a huge bulk of patent information. This is state of the art, what is written in Chinese language in all these millions of patent documents, and it is really difficult for a non-Chinese people to access to this because of the language barrier. And here, well, the European Patent Office was inventive itself and created a machine translation system, a new system in cooperation with Google. We do this, big US company, very experienced in translations. And we cooperate with this company and provide them with patent literature so that this translation machine, Google is already operating, learns also the technical language, the wordings which is necessary to understand patent documents. And we began with this machine translation system 1.5 years ago. We are already, with the first set of languages, we are already open for the public. We have improved this machine translation system in respect of the German language, the French language, the Spanish, Portuguese language, and the Swedish language. And our aim is to have this machine translation system available within the next 2 years for all our 28 languages in our organization. Our member states speaks 28 different languages. And in addition, we would like to have also the big non-European languages aboard. And therefore, we signed already memoranda of understanding for the cooperation in this respect with China, which is very important because of these millions of patent applications, with Japan. Japan is also a very important player in the patent market, very inventive. And just this week, 2 days before, we signed such a memorandum of understanding with the Russian patent office. You attended this ceremony, you told me, 2 days before. And we would like to have also the Russian language more accessible for non-Russian speaking people. And this is a big challenge for all of us to get access to the information in these millions of patent documents. And we hope that with this service we can help a lot in this respect. And this machine translation service is free of charge, open to the public. Everybody can use it. You just can go on our website and click Patent Translate. It's a cooperation Google and European Patent Office. And then you can translate everything what you want with this system, and also your patent documents. And the first results we received in this first batch, in this first set of languages, are very much promising, that this will work very good, and this will help the third parties, the people interested in patent information, to get access to this information. And this, I think, is also a very good service the patent system can provide for the broad public.
Спасибо, Ремет. Я позволю еще задать.
Thank you very much, but I would like to ask another question to you, Anna Permley. Ray also will try to answer this question. Information is the price. The price when it may be of certain interest for inventors. What do I mean? It has already been mentioned that in exchange for monopoly, an inventor discloses the essence of the technical innovation. And there should be a certain algorithm in reproducing this solution or decision in innovation into life. No doubt, but we have to carry out a certain check. We have to see for ourselves that the information that we provide will be a detailed one, and it can this information can reach the inventors who are waiting for patenting. A question of mine will be whether the EPO or American Patent Office checks that with the help of this description, we may see the applied technical result before the patent is granted.
Maybe I can explain that description of the patent. So, and in this description, you can get information how you get this result which you achieved. And of course, you need to prove, to check somehow that it is possible, for example, while using this description to get this technical result. It's not just a fantasy. Do you check it? And it's the same question to you. This is called enablement.
Yes. Yes. Well, the patent, the inventor has to describe his invention in the patent application, and he has also to describe, to show that it works and how it works, enabling the access to this invention. But, well, our examiners are checking this, but we are not doing, we do not prove, we are not making examples or so that we are trying to bring this invention into life. This is not our task. We are more or less theoretically checking whether this could be possible that this invention works. And well, this can be challenged then in an appeals procedure, and then the patent holder has to provide a bit more information perhaps, and then if it is possible, then the patent will be held up, and if he cannot provide this additional necessary information, then the patent will be withdrawn.
Okay.
I agree with Raymond, with everything that you've said, and I just want to make sure that we have actually answered your question. So our examiners do not duplicate with scientific scrutiny the information that's disclosed in the patent applications, but that's actually the benefit of litigation. The court and the legal system are very good because if a third party, another member of the public, thinks that the patent application that was filed, that we granted, that our examiner granted, did not provide a good enough disclosure such that when the patent term ended and the general public could actually make the invention without owing any obligation to the patent owner, if a third party involved in that science and that technology says, "Phew, this is nothing, it is air, it is magic," then a third party has the right to file litigation. For instance, with my good friend Judge Voigt, the problem is not mine. It gives business to Judge Voigt, and he must make the decision. So in the United States, most of our applicants are very careful to provide what we consider to be sufficient enablement and a written description because they know their competitors review the patent specification very carefully for any errors. And if there are errors, the patent may become either unenforceable or invalid if Judge Voigt does his job.
Not me alone.
Thank you. Yeah.
I just wanted to add a couple of comments to that. I certainly agree with what both of my colleagues just said. I would add to what Terry just said that challenge in which a competitor may look very carefully at the patent doesn't need to occur in litigation. It could occur in the nullity action. It could occur in the USPTO's new post-grant review procedure that was implemented under the America Invents Act. One of the beauty of those challenges is that litigation is not necessarily required for someone threatened by the patent to try to bring that information forward. The other thing I would point out is the need for someone to check and prove the viability of the invention for its intended purpose really depends quite a bit on the subject matter of the invention. Most technologies, once described to you, are relatively simple to see that they actually will work for their intended purpose. It is in the less predictive technologies, perhaps in chemistry, where oftentimes the efficacy of the invention isn't as well established from the description of the invention itself. So in many cases, it's actually very easy to check the kinds of things that I just heard described.
Следующий у меня вопрос.
And the next question to Quentin, once again, it is related to an access to information. Well, your company has acquired certain methods in treating the information that it receives, and I want you to tell a little bit more what this patent information gives to an inventor from the point of view of future commercialization of a patent. And please, your remarks to what has already been stated during the morning session. Thank you. Пожалуйста, покажите слайды моего выступления. Благодарю вас, Игорь. Как и многие участники данного форума, моя компания рассматривает патенты как формы подачи информации, и поэтому
technology library, if you like. And it's a library which my business and many others index and analyze and search across for various reasons. I think something that's come out tangentially from many of the comments, but I just wanted to make explicit, is how very, very complex modern technology systems are, and also how very diverse modern industries are. So the patent system is often criticized for being a one-size-fits-all system. 20 years, no matter what technology area you're in, 20 years for no matter what industry you're in. I don't think that's such a problem. I think industry has ways of working around this. But my first pretty picture is an illustration of a nanomaterials value chain and the various components that go into the production of nanomaterials and products containing nanomaterials. And the point of the slide is around the complexity. And that's one of the challenges for inventors, Igor, is that these systems rely on other systems and other processes around which patents already exist. So there are significant challenges sometimes for inventors in trying to understand who owns which aspects of technologies and components on which their own inventions rely. It's similar to what some of the other speakers were talking about earlier with the light bulb example, for example. These incremental improvements on what's gone on before can be very significant and very valuable, but it's important to understand what's gone on before. So one of the things we're doing is trying to decompose technologies into their various components and their various systems. Something else you mentioned earlier, Igor, which I think is very important actually, is to do with what I think of as capital-intensive industries. The idea that if you're investing a lot of money and time into developing a product, you might need a significant amount of time in which to benefit from your technology and your investment in the technology. And something that we hear our clients saying in the health and life sciences sector, some of the biosciences sectors, and also, say, in nanotechnology, where there's a lot of investment into R&D and a long time before products get to market. They say to us that the terms of patents are not long enough. We need longer, in fact. In other sectors, where the innovation cycle is shorter, so some other software sectors, for example, the telecom sectors, clients are saying, oh, no, we don't need a patent for 20 years. But that's okay. They just abandon the patents if they don't want them. I think that's fine. But in the pharma sector, I was saying industry has a way of working these things out. And this slide is just illustrating how in the pharma sector, there are various ways and methods that companies use to extend the term of their IP protection. So data exclusivity, market exclusivity, and so on. And also, I think you mentioned reformulations and this kind of thing. But something that I thought also was interesting that has been touched on a couple of times is, and I'm absolutely astounded that you guys are thinking about this too, but we are working on developing a collaborative patent search platform. And the idea is that our clients, who tend to be major corporations and sometimes governments, but our clients tend to want to have some people search across the patent data, to share the information that they found, to rank results, make comments on results, share that with others, share that selectively, and then share it some aspects of the work publicly. So one of the things, and it's actually a side point on this slide, was we've been working on developing some collaborative search platforms. And again, I think if you think of the inventor perspective, of the individual inventor, that can be helpful in inventors doing DIY, do-it-yourself, patent searching, sharing with their experts, their legal advisors and others, getting their comments on one online, easy-to-use system. So that's part of the rationale that we're trying to adopt there. Igor, I'm not sure that addressed all of your question, did it?
Сейчас будет возможность послушать вопрос.
And now we shall listen to the questions from the audience. And I think that many people would be able to participate in the discussion. Now, I wonder whether you have any questions or would like to make a statement, please.
Микрофон возьмите, пожалуйста.
Alexei Strelkov, Director of the Federal Institute of Industrial Property, Moscow, Russia. Well, I put down the chronology, and I would like to launch a kind of a discussion with the European and American PTOs, because FIPS, or Federal Institute of Industrial Property, is the institute where we have all the patent examiners in Russia. They are within the walls of our institute. Let me start with the following. Well, a patent law is not 100 years old. No. If we take 300 years ago, the year 1700, 300 years ago, Peter the Great understood that the development of the country is possible only with the development of manufacture. And in 1700, a privilege was given to give the license and the patent for the sewing factory. They manufactured products for the construction of vessels, of ships. And the privilege was the following one. None of the employers of this factory should not be enlisted in the army. And that was the first privilege. The second privilege was 1736, when this privilege has already been granted, but it meant the emergence of the fundamentals of the patent law. mainly it was the dyeing of clothes, and that license said that there should be a life for the patent and protection life for the patent to protect the rights of those who invented this technology and used this technology. More than that, it was also mentioned that the owners of this technology should not keep sacred, so that their employers, by stealing this technology, would sell it for free. So the principle, therefore, they published this privilege document. And that was the basis of the patent law. In 1752, a privilege was issued or granted for 30 years to Michael Lomonosov for the production of mosaics. Before that, it was imported from India and France, but he invented the method for production in Russia. The first law on privileges for different inventions and discoveries in arts and handicraft, about 200 years ago, and I would like to congratulate you all on this day. This law on March the 30th gives the main concepts of the patent law: territory, the life period, and privileges. This is the first stage. Well, in our country, it was not 100 years old, but a short period of protection, only 20 years. Well, this is a normal period.
During those 20 years, it is sufficient time to benefit from your investments. And more than that, statistics gives that the average life of a patent, when it is supported, is about 8 or maybe 10 years maximum. So 20 years is more than enough to recuperate your investments. This is only very few patents that live that long. So to expand that would not be. But patent life for pharmaceuticals can be expanded, which is connected with the need to obtain certificates from the ministries of health under the examiners. Let's speak about examiners. Yes, there is an issue indeed. Experts, examiners should be experts in all fields. They're supposed to be experts in all fields. There is no institution, no university, no college could prepare examiners for patent offices. Yes, this is indeed an issue. So fast science and technology are progressing that education which they may receive 5 or 6 years ago in the technical colleges become obsolete very quickly. They have to move faster. So there is an issue with examiners. That's true. And this issue, this challenge, not only exists in Russia. It exists in Europe, in the US. This is our common challenge. A solution, a possible solution. Well, I was surprised. I didn't hear any proposals in this respect. There is one. Fast, shortened patent system. The first agreement of this type was struck, put in place between US and Japan when, the first application is made and protection is required in 2 territories, in 2 countries. The first patent office conducts examination, sends these results to the second patent office in the second country, and that second office accepts that result, so that not to duplicate the work. This is a system of speedy, patent issue in Korea, Finland, Japan, China accessing to this system, and I believe this is a solution. This may be a solution to the challenge of short of examiners, shortage of examiners, access to patent information. Indeed, you, Igor, said, perhaps yesterday, that 60% of duplication of R&D. Yes, that's true. I would corroborate this number. Yes, it is absolutely necessary. The patent information is required. The access to the patent information is necessary. And non-patent information is also important for us. Though we're in the program speaking about the copyright, we did not actually touch copyright here in our roundtable. We have patent rights which are protected, and some protect the rights through publications. It's a non-patent form of protection, but the results belong to that person. But in this case, the Institute of License would not be applicable, but the person has made a statement that he has invented something through a publication. In non-patent literature, there is huge, mass area of information which sometimes is not taken into account and is not studied enough. Intellectual rights property organization a year and a half ago commenced a project to develop centers to support the technologies and innovations. Last October, agreement was signed. Francis Gehry and Boris Simonov in Geneva signed this agreement concerning creation of this network in Russia. And in so doing, we met with the then Premier, Mr. Putin, and a number of centers, it was agreed, would be at least 100. So far, we have on April the 17th in FIPS, we had a ceremony of signature of protocol with the deputy of Francis Gehry about opening such centers in Russia. As of now, more than 50 such centers have been already created. The mission of those centers is as follows. We would pump, if you will, into those centers all patent and non-patent information through a high-speed internet connection. We provide access to the public. We train people who would work in these centers how to use this data, how to make search of this data, how to define the database FOIs, and many other variety of databases are available with those centers. So we teach them how to navigate in these networks. The first workshop will be held in St. Petersburg. It will start on May the 25th, and any one of you is interested and would like to feel how the patent and non-patent information can be obtained, you're most welcome to be present at this workshop where we will conduct the training. It will be a workshop actually for people to learn how to work with this information. Lengthy time for a patent examination, and the question whether it's possible to commercialize your rights before your initial patent is issued. You can commercialize it at any phase. Of course, initially, you look at the document before the publication so that there should be no, infringement of rights. You search a variety of systems. When 6 months have elapsed, these results is published, and this result through publication, though patent is not yet granted, this is a temporary legal protection is granted, which shall already belong to the person who will be a future patent holder, though it is not sure that he will get the patent at the end of the day. So the duration of the examination, it is a challenge. It is a very important, real challenge. There is a certain set of rules in the patent law which basically define the duration of the, when a publication should be made. We apply the international rules for that, though the national legislations have been more or less harmonized. It may differ a little bit, but in various minor detail from a country to a country. But basically, the national legislations has been harmonized in this respect. To shorten down those periods of examination, we have come up with this speedy patent registration, and new system, modernized system has been thought of, which is based on the PPH, where expert speedier examination can be done. Basically, certain alternative to the PCT system is being now developed, but this is on the drawing board stage. It's not a public discussion, so it's within the framework of bilateral contracts or agreements between two countries. There is not yet a single system, a universal system which would be applied for all. So So you can start to use commercially your rights at the phase of application. Machine translation, it is an issue too. An agreement was signed between the Russian and the American patent offices to enable using this PPH system. However, they tested the PPH system, and now to ease the backlog in our Russian patent office, which is also an international office, is doing the examination of those applications which were filed in the United States. We do not take decisions, but we conduct examination. There are such certain agreement of this kind have been reached between the two parties. So we are trying to help each other, fully understanding that indeed the situation is rather delicate and complicated with the realization of patent laws. Yes, this is something which should be done, no doubt about that. We have common positions, they are defined, they are harmonized too. In principle, in national legislation, you may find certain legal loopholes, if you will, which should be addressed on an ad hoc basis. For example, a very simple example, in the Civil Code of the Russian Federation in Part 4, which is currently being updated, when the Part 4 was created from the patent law, something was borrowed and something was not borrowed. They failed to take all this, and they said that Ross Patent Agency takes decisions on issuance or on refusal to issue a patent. A decision. But now it comes to realize that everything is fine with the patent holders. They have time. If he misses the time, he may pay additional duty and expand its period to do additional, work on search, to be able to, for experts, for examiners, better to understand what he is talking about. Actually, sometimes the text is not clear enough or obscure. So he has not responded in a period of time, and a decision comes to that his application was refused because he failed to meet the time period. But in 6 months from that, he recalls that it is possible to pay additional duty. He pays, and the application should be restored. But in our civil code, the mechanism of restoring, revoking these, lost cases has not been addressed. So this is a simple example of a loophole in the current law legislation. Machine translation is indeed a very important issue, as I mentioned. Well, as far as the English language is concerned, there is not great difficulties, but indeed with other languages like Chinese language, French, and so many other languages, we are facing issues. Well, right now, unfortunately, machine translation does not meet the quality criteria, because of course you have to find human translators who can translate, especially if an application has been filed in Chinese or in French. So indeed we have to find human translators. This is an issue, a real issue, and in principle machine translation is developing. It appears to be improving, but still it is far from being acceptable, providing acceptable results. Well, my last comment. Well, it's a very rare situation for me to see all my colleagues in one place, so I would like to respond to their questions. In what way examination is done, whether results are achieved or not? It is on the theoretical check. We can understand that the applied results are examined by an examiner, and he has to judge whether it is possible to achieve those results or not. And if the applicant has failed to convince the examiner that it is possible to achieve the results, then his application will be refused. But nobody conducts physical experiments, otherwise we would not have the time available to us to do the work we're supposed to do. Yes, I have a question to Teresa. But if Thomas would be kind enough to respond, I would also appreciate. My question are not simple ones. I am a judge of the highest federation courts, and we review those patent litigation, and our life is far from being dull. One of those court litigation about minor change, incremental innovations. Do you think, what is your opinion about the following? Recently we had the case, two Russian companies were litigating of who of them invented mayonnaise sauce. Mayonnaise sauce. Mayonnaise sauce. Mayonnaise sauce, you know? Yes. I understand that everybody has loved, because everybody would understand that we do not even the name of the person, but definitely, since it's a French name, those were the French who invented mayonnaise sauce. So two companies litigating, they have certain incremental innovations. Both companies produce mayonnaise based on the, say, not chicken eggs, but turkey, say, case. And one company said that they add fresh eggs, and another company adds say smoked eggs, if you understand what they have in mind. So the question, if we speak about those minor incremental innovations, are those innovations expected to be indeed innovations, or if I, for example, can prepare the scrambled eggs with, say, ham or, say, tomatoes, is it subject liable to patent issue? Understand, this is a funny issue, of course. That's why, where is this dividing line of those small incremental innovations and those changes which are not innovations at all in the recipe? And then I would like to have a chance to ask my another question. Well, indeed, that was one of the cases which came up to the high arbitration court, Supreme Arbitration Court rather, and one of the peculiarities of that litigation was that on one hand, there was a patent with the claimant, and he claimed that the defendant, say, violates his rights, and the defendant also has a patent. And on the other hand, he said, the defendant said, I have my own patent. Yes, they issued two patents, and the court rejected one of the company in suing the other company. So the court said both companies can produce mayonnaise, since the French are not objecting to your producing mayonnaise sauce. And okay, so to what extent the grounds of the defendant to the fact that he has a patent was grounded or not? That was interesting.
When I talk about incremental innovation, I am still saying there must be innovation. So when we get a patent application, our perspective is to review it from the perspective of one of ordinary skill in the art. And the difference, the modification of the prior art, the new information, the fresh eggs, the different color, it must be something that is new and unexpected, and one of ordinary skill in that technology would not have considered that modification. So if a child who has learned to cook at home has fresh eggs, not so fresh eggs, and when you make a souffle, fresh eggs are better, even a child could discern that difference. Certainly one of ordinary skill in the art would appreciate those benefits, and if my examiners did their job, they would not issue that patent. So when I say tiny innovations, it must be something new and unexpected to people skilled in that art and technology. And we do issue food patents at the U.S. Patent and Trademark Office. And for instance, Cornell University has a very good food and science department. And they came up with cookies and crackers, each packet 100 calories or less, which is good for me. But the taste is very good, and the taste is like an Oreo cookie or a cheese cracker, but only 100 calories. To me, once again, those are important incremental innovations because it helps keep my weight down, okay? But it had to be a true innovation. Tiny changes can still be true innovation. And look at it from the perspective of someone skilled in the art. Sometimes someone skilled in the art simply has a high school degree or a bachelor's degree. Sometimes in the United States, in biotechnology, we say that the person skilled in the art has a PhD plus 10 years of work experience. And that is how elevated we look at that person skilled in the art. And they know much more than our examiners know. But that is the perspective they must take. And Judge Voigt, you may disagree with me if you wish.
No, not at all. I can only confirm Theresa's statement, and you have to get a patent. You need a novelty on the one side and an inventive step on the other hand. And if there is nothing, and if I understood your case correctly, then there is nothing at the moment because mayonnaise is well known for 300 years, 400 years, I don't know. There is no novelty, and I think, as I understood your case, both patents are null and void.
I can add a couple of comments. Both parties used the egg powder, to be precise. Well, what was the crux of the matter, and what complexities it revealed in the court system of Russia? The crux of the matter was that both parties, contending parties, added additives to mayonnaise using not chicken but some other types of eggs, and the patent office put a decision to issue patents because it took a decision that the technical result was improvement of certain tastes of so on behalf of the patent office they issued a patent on solid grounds, but otherwise those parties would contend their refusal. But this case revealed something more important. It revealed that unfortunately in our court system it is not possible to consider two cases about infringement and the validity of a patent within the same case. And the court also took a very valid decision saying that, dear sirs, from our point of view, both of you have grounds to use their own respective technical solutions in production of your mayonnaise, which have different tests. And then if you go back to the Patent Office and decide with them who has the prevailing right to use the patent, and if someone fails to support its technical, and when you sort your things out with the Patent Office, come back to us and we will review your case once ago. So this is one issue which the U.S. system is not does not know, and maybe in German system does not know. So it is not possible within one court case to at the same time, in response to the claim that you have invalid rights. And now courts do not even delay court case for consideration if a party files complaint to the Chamber for Patent Disputes. And the Patent Office turns out to be guilty. Why? It is not true. And if you speak about utility models, in respect to which we have, from my point of view, because we consider the protection right, we had a utility model institute which was introduced aiming at culture of borrowing foreign experience where it works fine, and it used to work okay. And our Rospatent Office was issuing patents on the basis of the presentation of examination results. But then some parties appeared who started to abuse those rights. And what the decision was taken in changes of the state civil code to say introduce system of checking the examination. Nobody would be using those utility models that will be the same examination period, or Rospatent office will say do your examination faster, and no expect instead of adopting a German model when you want to file a claim in the court, okay, go to your results of the examination, you can use this evidence in the court. Or on the other hand, we should look into view in one case called the dispute about the violation and the validity of patent rights. This is one of the matters which we are indeed facing. I would also like to add a couple of comments. A very important issue was raised by the judge of the Supreme Arbitration Court, because the court sometimes does not understand correctly the foundation principles of the patent system. What patent system is all about and patent law is all about. This is a law to prohibit others to use your invention, but not the right for you to use your invention. So in the court litigation, in court courts, a patent is a tool of aggression, if you will, and not a defense tool. So the claimant, being a patent holder, may prohibit others, any person who uses his invention, to continue to use this invention commercially. And in so doing, it is not important whether the defendant has his own patent or whether he does not hold that patent. It is irrelevant issue. If the defendant believes that the claimant violates his rights, he may ask a counterclaim where he will turn out to be the claimant, and the other person who is claimant in this case will become defendant in another court case. But in this case, we had a mixed situation when both parties produced their own patents, and they say that the claimant said that the defendant violates my invention, while the defendant says he holds his own patents. This is a very dangerous situation in the development of the patent system and the court review of such cases.
Yeah, I just wanted to add to something that Terry said a minute ago. She described dealing with incremental inventions based on the U.S. doctrine of inventiveness and the level of ordinary skill in the art used to judge the obviousness of that invention. And there's a related doctrine in the United States, and I think it ties back to some other issues we've discussed here today. And that's the doctrine under which one determines whether an inventor has sufficiently disclosed the invention in the patent application. And in the United States, we once again talk about the person of skill in the art and whether the invention has been described so that others could recreate it without undue experimentation. It's a similar doctrine, but it goes to the description of the invention as opposed to its obviousness. And I believe one of the problems in the system that it is a difficult problem, more difficult than the issue of incremental invention by itself, is getting a consistent viewpoint of these doctrines. It is not uncommon, in my view, for an examiner to examine as if that level of skill is rather high when considering the amount of disclosure in the patent application, and then flip-flop and in considering the inventiveness, assume the level of skill is low. And then similarly, when we get to court, we have yet another standard bearer again, because now we've turned it from the examiner to a judge. So the problem, in my opinion, isn't just that the inventions are incremental. It's getting a consistent standard applied in all of these circumstances that tie back to that same thing, that level of skill in the art.
I have two questions. The first question, you have described a rather static system. You said the patent system was fine, it is fine, and it's going to be fine. But I would like to hear about certain trends and challenges that we are facing in your field of activity. And you say that everything is fine and rosy. This is not, of course, good. So let us speak about the patent protection of software, for example. Let us speak about the patent protection of nanotechnologies. Well, it is not easy to cope with this area. Nothing was said about to what extent the patent system is accessible for companies when we speak about not transnational big companies, big bosses, or small and medium-sized business. And another issue with U.S. patent law, for example, in 1997 the patent was issued for manufacturing of growth of basmati rice, type basmati rice. It was a pirated issue. It was also an issue. So it's an evident issue. It can be proved that India created very strong at the level of the state electronic database, and now they are interacting and cooperating with the European countries and with the US. So there is an issue, and in this case those incremental changes, innovations, an issue. I would like to hear a comment from some of you.
I'm going to let Manny Schechter handle the software issue because that is his area of expertise. But before he does so, I would like to clarify the basmati rice issue. And we conducted a re-examination in the USPTO, and that patent is no longer valid, is no longer in force. And the problem was identifying the prior art. So we have worked extensively with the Indian Patent Office. The European Patent Office has worked with them as well. And we work with them, and the Indian Patent Office has many old publications, not just in Hindi, but in Sanskrit. And some of those publications are written on old leaves of plants. For us, my examiners, to find that prior art that is not available, for instance, in a book or on the internet, it is a very difficult job. So we are working, because India is an old country with a lot of old innovation, and so we have certain databases that the EPO shares with the Indian Patent Office as well. So the basmati rice analogy is not valid, and not only that, we had no way to, because India does not publish that old information. It is word of mouth, or it is on tiny pieces of paper that are falling apart that India is preserving at this time. So that is not a valid. The second thing before you handle software is that technology moves fast. The law is slower. So we are always changing what we are doing in the patent office. Do I think it is a good job right now? Yes. I worked for a corporation from 1980 to 1984. I was a lawyer from 1984 until March of 2011. I know the patent system from the other side. Now I have a unique opportunity to be in the patent office to change it as I think it should be changed. Will we be perfect? No. But we are trying to do a good job. I do think things are fairly balanced right now, but as technology moves, for instance, software, we have to be ready to change. We constantly innovate what we are doing in the patent office, not just procedures, but how we apply the law, but we must be consistent with the courts, and we must be consistent with what Congress tells us. But I think we have a fairly good balance. I could be far more critical than you, because when I sat in your chair, I was president of AIPLA, the American Intellectual Property Law Association. So we always critiqued everything, and we wanted a balanced patent system that was efficient, predictable, and cheap for businesses, so they can do their job, so they could invest money and build a plant and not worry about copy. So, but I just wanted to clarify that. Software, Manny, I leave that to you.
He
Well,
has asked to speak before me.
Before I pass over to my colleague from IBM to talk about software, you mentioned nanotechnology as a challenging area. And I wanted to use nanotechnology as an example of an area which is challenging through no fault of the patent system. So in the area of nanotechnology, many experts have trouble defining what is nanotechnology, many experts. Also, it's an area in some aspects of nanotechnology like graphene. It's an area where there's a lot of commercial interest, a kind of gold rush, if you like, towards R&D, towards patenting and so on. And the names for the components aren't yet settled in the scientific literature and the scientific community, let alone in the patent literature. So I think it can be a real challenge for the patent examiners and the scientists and the researchers to understand the technology, to describe the technology effectively. That's not the fault of the patent system. That's not the fault of the patent examiners. It's a feature of a kind of modern technology development process. And I think we have to accept that there will be some level of discomfort, some level of, in inverted commas, mistakes. So say multiple patents granted over the same thing called by different names in different countries. It's going to happen, not necessarily as a fault of examiners or the system, just because things are happening so quickly, things are so complicated, and the terminology in the case of, say, nanotechnology isn't yet entirely settled. So I don't think the patent system can be like a silver bullet, as we would say, to solve all of the problems of innovation and, and commercialization. But I do agree that there's improvements that can be made. I think we need to be cautious about making improvements, though, because there can be unintended consequences if radical changes are made. And as I tried to make the point earlier, businesses have already learned how to work with the existing system and the existing framework. So, you know, one would have to be careful about making radical changes because it might upset the apple cart, so to speak. Yeah.
I'd like to clarify my position. I don't blame the system.
Okay.
But I see only that it would be great that you share some problems with your colleagues.
Yeah.
Some problems, not only glorified.
We are human. That is our biggest problem.
May I comment now about software? The usual criticism I hear about software is the large number of patents and the incremental nature of the inventions, and usually it leads one to say, why don't we just get rid of software patents? And aside from the fact that it's many of the software companies that are now actually in litigation and clearly in many cases enjoying their software patents that are in the phone wars. There's a more important issue at stake, one very fundamental to the patent system, and that is that in most countries, most patents relating to software are not claimed as software. The software is described as a process or a method of doing something. It's logic that is used to program a machine to do something. In the description of that invention, it may be described as implemented in hardware, in the wires, in the silicon, or it may be described as implemented in the ether of the zeros and ones of software. Or it may be described in both ways. But when one gets down to actually expressing one's rights in the claims of the patent, those elements are typically not present, which means that in most cases, in many cases, we cannot distinguish truly a patent for hardware from a patent for software. They are in fact often one and the same. And if we say that those inventions may only be protected for hardware or enforced for hardware, we are actually setting technology back. We are turning ourselves backward if we believe that the patent acts as an incentive, and promotes innovation, why would we want to promote it for hardware and not promote it for software, when in fact the reason why software is advancing so rapidly is because it is more efficient and easier to develop in software than in hardware. So to do otherwise, to my way of thinking, is actually going backwards in time, and I don't think it's appropriate. I do think it's appropriate that we judge software like we judge any other invention, and we ensure that it meets the same standards of novelty and inventiveness. And I think one of the problems is what Terry touched on a few minutes ago when she said that the law can't keep up with the technology. By definition, we're talking about innovation. The innovation has to occur before the law can adjust to it. If the law could adjust to it before the innovation occurred, it wouldn't be an innovation. Therefore, our problem comes from the fact that we cannot always train the examiners quickly enough because software is advancing so quickly. And what we have to focus on is making sure that our examiners are trained and up to speed so that they can do a good job of examination as quickly as possible. And it's in that time frame between when the technology develops and when the examiners catch up to the technology that the patent offices are most susceptible to making errors in granting patents that they should not.
Well, we have very little time left. Anybody who would like to ask a question?
У меня вопрос связан с тем, что интеллектуальная собственность объединяет в себе.
We'll have a question that by intellectual property we mean the rights to copyright and to inventions. Well, in copyright, well, the standpoints taken by lawyers are extremely powerful. But in the patent law, as far as I understand, quite habitual is the protection of the commercial interest. So why then it should be viewed as the right to intellectual property? Thank you.
Copyright law protects songwriters and people who do print. Those are commercial interests.
Originally, copyright protection, as people suppose, was created to protect author. And here I understand that patent protection is created to protect business, but not the inventor. And I want to know your opinion about the role of inventor in a patent system and the nature of patent protection. Because if patent protection is not for the author, why shall we protect it as in the intellectual property right? Because the intellectual property right basis is creativity and creativity of the individual.
Okay, and the invention also belongs to the inventor, the individual, and the inventor has the right to assign or license his technology to a business. Usually an inventor would like some monetary benefit. Usually an author in copyright likewise wants a monetary benefit. And an author of print publications will give a license to a book company to publish so they can make money. I have never heard this distinction before, but unfortunately, both copyrights and patents involve money. And why that may sound distasteful, because we are talking invention and creativity and precious ideas, but it is those precious ideas that improve our lives, make it more convenient, improve our health, and gives us the movies that we want to see, Men in Black 3, which I hope to see soon, okay? But I am willing to pay to benefit from that copyright creativity because I want to enjoy it and I want them to continue creating. So there is no difference in terms of protecting authors, protecting inventors. Both intellectual property, both can manage their intellectual property rights in a variety of ways, and generally they decide to manage their rights by making money for them and their family. And that is a good thing because it creates businesses and jobs, and that is what I want.
Thanks. So in our business, we regularly see inventors, individual inventors, normally leading academics, who are filing patents in their own name and seeking to pursue them. They only ever do so, I think, because they're looking to make money out of it. I had one academic saying to me, he was in the health sector, saying that one of his concerns was to see that his invention was deployed correctly. So he wanted to ensure that everyone should take a license to his patent and use his technology as patented so that no harm came to other people. It's kind of like a standard. But I think it's very unusual. I think normally it's individual inventors and they want to make money out of it. So perhaps what you're saying, I don't know, is that in your view, copyright tends to be more about artistic kind of expression, although there's money to be made out of that. Whereas patents tend to be made more out of the motive of business protection. Is that right? Yeah, okay.
Now, well, we have very little time left, but this is a very important philosophy for people to understand it. Copyright and patent law, they're absolutely similar. They have much in common, since the authors in their copyright, their innovation is that they create a certain image and not a personality. Besides that, they place this individual into a certain situation, and this is an innovation. Think of an image invented and the place where this image should be placed. Well, what I tell you right now is an idea which I cannot sell, unfortunately, and I regret I cannot do it, although it is an idea, but I'm glad that this idea could be used in public. And the last question, please. If no questions, then I would like to emphasize that today the discussion was extremely interesting, and the comment was that you didn't discuss the problem, but you discussed only the privileges that the patent law has, because we may discuss the problem of setting up the court on intellectual rights, and no doubt we would like you to be more critical in respect of the patent rights. Well, a critical attitude to something is the possibility of checking the validity of what exists. Thank you.